We got several bills to go through, and as everybody knows, we've got to be back upstairs at 5:30. So we're going to try to move through this calendar as quick as we possibly can. A lot of these bills are identical bills, so we're going to move through them as quick as possible. So everybody present, if you'll vote aye on electronic voting board.
You can too. Can you chime me in?
Yeah, I got
You have a quorum, Mr. Chair.
All right. First of all, we're going to take up the identical bills. House Bill 1865, it's Delegate Fowler's bill, is identical to Senator Morrison's bill that passed out of this committee on a 13-0 vote. And it's been moved and seconded. We report the bill. All in favor, vote aye on electronic voting board.
Twelve ayes, 0 nays.
Bill reports 12-0. Next is Delegate Plum's bill, House Bill 2578, 6-year plan for secondary highways, identical to Senator Peterson's bill that passed out of this committee 13-0. Is there a motion? Moved and seconded that we report the bill. All in favor, vote aye on electronic voting board.
13 ayes, 0 nays.
House Bill 2784 is the one that we've heard extensive emails about, Robert O. Norris Bridge. This is identical now to Senator McDougal's floor substitute, which reported out of here 11-0. And is there a motion on the bill? It's been moved and seconded. We report the bill. All in favor, vote aye on the electronic voting board.
13 ayes, 0 nays.
House Bill 2800 is identical to mine once we add a line amendment, if that could be reported.
Mr. Chairman, the amendment is on line 23 of the engrossed bill after the strike commission, insert commissioner.
It's just a technical amendment. It's been moved and seconded that we adopt the amendment. All in favor say aye. All opposed. Now the bill is identical to 2800 to Senate Bill 1775. All in favor vote aye on electronic voting board.
13 ayes, 0 nays.
13-0. Next is Senator or Delegate Bell's bill, House Bill 2344. This bill is has a couple of line amendments, and it puts it in the same nature as Senate Bill 1520, which reported from this committee 13-0. If you could report those amendments.
Mr. Chairman, there are 3 amendments. The first one is on line 81 of the substitute after accidents, insert and. The second amendment is on line 82 after revocation, strike comma and, insert period, the commissioner may also release. And the third amendment is on line 273 after driveway, insert, and the bus is put in motion.
So these were some technical amendments that was found after the bill reported. Now both bills are in the same posture. Is there a motion? It's been moved and seconded that we adopt the amendments. All in favor say aye. All opposed? All right, now the bill's in the same posture as the Senate bill, and that bill reported 13-0. Is there a second? All in favor vote aye on electronic voting board.
13 ayes, 0 nays.
Next is House Bill 2514. This is dealing with motor vehicle safety inspections. It's identical to Senator Barker's, but there is a line amendment that we... Okay, let's take this by just a few minutes until we get Delegate Hugo. We did. I was going to talk about that. The next bill is Delegate Thomas's bill dealing with mass transit providers. It needs a clarifying technical substitute to conform it to 1680, and then we'll have to refer it to finance if we report it. Can you
Mr. Chairman, the substitute would conform it to Senate Bill 1680, which just specifies which department the funds would come from, which is the Department of Rail and Public Transportation.
So they're only moving the money around within their own budget. All right, it's moved and seconded. We adopt the amendments. All in favor say aye. All opposed? All right. Now is there a motion to report and refer to finance? It's been moved and seconded. We report and refer House Bill 2553 to finance. All in favor vote aye.
13 ayes, 0 nays.
All right, the bill is reported and referred to finance. Is Delegate Mayeres here? All right. Delegate Peace. Okay. Delegate Ferris. I couldn't see you.
Yes, sir, Mr. Chairman.
So whose gate's been put up that you can't get through?
Well, it's a good question. No, really, Mr. Chairman, members of the committee, this is a problem that I don't have, of course, because I'm a good neighbor. But this deals with landowners and right-of-ways, and a gate is fine as long as the only reason is as long as you're corralling or keeping out animals, as far as that goes, deer or cattle, either one. But when you're maliciously blocking roads, it creates an issue.
All right. Any questions to the patron? How many you got to line up to speak in favor of this bill?
Mr. Chairman, I knew y'all were smart enough. You didn't need to have anybody tell you what to do.
All right. Is anyone in opposition? Seeing none, there's a motion to report. And second, all in favor vote aye on electronic voting board. It's Freedom Bill.
13 ayes, 0 nays.
Thank y'all.
Thank you. Delegate Mayeres, we're gonna, all right, so this bill is the companion to Senate Bill 1335, I'm sorry, would be 1464 that came out of this committee, 13-0. I know you have some line amendments. If you want to report those so that we can take those up.
Yeah, the committee should have some line amendments.
Mr. Chairman, there are 3 line amendments. The first one is on line 13 of the engrossed bill, after dealership, strike, or a proposed change in management of a dealership. The second amendment is at the beginning of line 39, strike upon, insert after. The third amendment is on line 39, after refusal, insert consistent with subdivision 2 of section 46.2.1572.
All right, is there a motion? All right, it's been moved, seconded, that we adopt the amendments. All in favor say aye. All opposed? All right. How we're going to do this is, since we've already had an extensive hearing on this bill, we're going to give the delegate his time to present it. Then we're going to start the clock. Ever who you have want to speak, it's going to have 5 minutes to do theirs, and then the opposition will have 5. And any questions that the committee will have will be after that.
Thank you, Mr. Chairman. So this bill addresses 2 issues concerning the franchise relationship between new motor vehicle dealers and manufacturers. It is identical to actually the 2 pieces of legislation already heard in this committee. The right of first refusal heard by this committee as Senate Bill 1464, and the discontinuance of a manufacturer bill carried by Senator Cosgrove, Senate Bill 1333. Obviously, we've had a couple of amendments before this committee, and just so the committee is fully aware, this makes a clarifying change and ensures that the language of the exemption for minority dealer development programs is broad enough to cover the existing program and manufacturers. These same changes are made to SB 1464. It removes some new language that's not necessary given the amended bill. This language also ensures that minority dealer candidates have a real opportunity to become dealership owners, and we believe the existing language does exactly that. I would also, many of these programs provided for minority candidates to buy a majority share of the stock of a dealership over a period of years, General Motors has approached us with these changes, and the manufacturers to make sure it is clear that the exemption would apply so long as a minority dealer candidate was participating in their program and a contract to achieve 51% more ownership. At this point, actually, I would like to ask Damon Lester with the National Association of Minority Automobile Dealers if he could come up and speak about this issue, if that's all right with the chairman.
Oh, yeah, that's even better.
Thank
Good
you,
afternoon.
sir, and welcome.
Thank you. Thank you. I am Damon Lester. I'm president of the National Association of Minority Automobile Dealers. We're located in the Maryland, Washington, D.C. area. NAMAD's mission is to increase the number of ethnic minority-owned new car dealerships in the country. Currently, out of the 19,000 new car dealerships, there are only 1,200 that are owned by ethnic minorities. And so in the state of Virginia, there's only 485 new automobile dealerships, and of which only 20 are owned by ethnic minorities. And so our goal is to try to achieve parity. As of last year, 30% of all new cars and trucks were purchased by a minority, and we try to achieve parity by making sure that there's opportunities for minorities to become entrepreneurs. So as you see, more than half, as I mentioned, over 19,000 dealerships, and more than half of those dealerships are third, fourth, and fifth generation dealers. Their generational wealth, their succession, and there's a slew of other advantages that multi-generational businesses have over the first and even second year small businesses. So for our industry, minority dealers weren't allowed to become dealers until the post-civil rights era. So the ability to create generational wealth and have opportunities are very slim, particularly in this day and age, as far as new opportunities. So I'm here to support, in support of HB 2174, and speak briefly about our advocacy for minority-owned dealerships. The bill you are considering and the amendments you are considering today will support our efforts to ensure that minority dealer candidates have a meaningful opportunity to own auto dealerships. The language you are considering ensures that minority candidates have a contract in place to achieve controlling ownership of a dealership when their manufacturer exercises the right of first refusal. So make no mistake about it, that this does not end our efforts in working with both manufacturers as well as our dealer body. We will continue to work to ensure that contracts and practices are put in place by manufacturers when working with minority candidates that are established in these dealerships so they do not undermine the success of those candidates. So again, we're here to support 2174. Thank you.
Thank you.
Hi, I'm going to keep my comments as brief as I can. I'm Liza Borsius, and I'm president of Carter Myers Automotive. Here in Virginia, we've got 16 franchises that we represent, about 600 employees in 13 locations. We're an employee and family-owned business through our ESOP. And the one comment that I want to elaborate on a little bit more is the fact that manufacturers control our businesses through our franchise agreements. They control the facilities that we build down to the tile in our showrooms. They control our websites and our marketing efforts. The one thing we need control of is our ability to be able to sell our business or buy another business without it being within the manufacturer's ability to mess up that deal through first right of refusal. If the language, the first right of refusal language, continues to exist as it is now, it will impact our future. It was valid back in the day when dealerships had one franchise in one dealership, but in today's business environment, it's simply not valid anymore. And I ask that you all support HB 2174 and allow us to be able to continue to be a dealer for many years in the future. We've been here for 95 years and hope to be here for a lot longer. Thank you.
Thank you. Welcome.
Thank you. Good afternoon. My name is Tom Moore, and I own Highway Motors Incorporated, based in Roanoke, Virginia. We're a heavy-duty truck dealership representing the international franchise in Roanoke, Harrisonburg, Winchester, and Purcellville. I'm the fourth generation to run this business and have the fifth generation currently involved. The dealership was started in Harrisonburg 90 years ago. We have 145 dealers in 5 locations. This bill came out of my segment of the auto and truck industry, and it's critical that we fix it. While heavy-duty truck dealers and car dealerships don't always have the same issues, this one is that we both have to address. Typical heavy-duty truck dealer, like my car colleagues, have developed into integrated operations with multiple franchises and locations. This bill is critical to our ability to protect the franchise of the family businesses. It ensures that we are protected if we choose to sell our business to a qualified operator. Manufacturers dictate enough to us already. They do not need to be able to come in and simply pick apart a purchase agreement that decimates the value of my business and my family's future. Please support House Bill 2174. Thank you very much.
Thank you. You have anyone else? Okay. Did very well. Had 20 seconds left. All right, we're going to reset the clock, and now we're going to hear from the opposition.
I'd love those 20 seconds. Mr. Chairman and members of the committee, I'm Greg Higgins, Senior Counsel for Volvo Trucks. It's our legal case that is the cause of this bill. As of today, a preliminary injunction remains in effect in federal court in Western Virginia. The day after this bill passed the House and the Senate, the dealer filed a motion to dismiss. Volvo Trucks vigorously opposes the motion because the case is not moot. The dealer agreement is a continuing contract that governs the relationship between the parties into the future. The dealer has indicated it will submit a third stock purchase agreement sometime in the future. We believe this bill seeks to eviscerate our vested rights, and we are entitled to a declaration of those rights under the continuing contract and under the statute because this dispute is likely to recur after they submit a third stock purchase agreement. Volvo Trucks believes it should be able to choose our own business partners. The new bill purports to require Volvo Trucks to accept any dealer licensed anywhere in the country by any other manufacturer. It allows our competitor, in this case Kenworth Trucks, to choose our business partners instead of allowing us to choose our own business partners in our own backyard. Heavy trucks and heavy truck industry is vastly different from the car industry. Heavy trucks are a business-to-business tool, and the scale is much different. With respect to cars, there are about 500 new car dealerships versus approximately 15 heavy truck dealerships in this state. Car buyers usually buy from a dealer close to home, and truck customers buy from further away and travel across the country all day long. Truck dealers' areas of responsibility are massive. They often involve many counties, whereas car dealers might only have a portion of a small town. Because trucks travel the entire U.S., we rely on a national dealer network and a network to service and support our trucks. In order to grow our business, we must have a nationwide network. Plus, every Kenworth truck sold is a lost opportunity for Volvo and for Virginia because it means the truck wasn't built here. Thank you, Chairman.
Thank you. Thanks.
Chairman, members of the board, I'm UAW member Terry Simone, hourly worker at Volvo Trucks, and we are against the bill. I feel that this would, beyond a shadow of a doubt, have a negative effect on the sales of the trucks that we produce, which in turn has a negative effect on the hourly workers, which in turn has a negative effect on families in Southwest Virginia. So we are definitely against the bill.
Thank you.
Thank you.
Chairman, members of the board, my name is Matt Blondino. I'm UAW Local 2069 President. We have over 3,000 members at Volvo North America plant. The dealers talk about the families. You're talking about 3,500 families. Within the last 2 years, we've grown from 1,700 members to over 3,000. We're a 95% UAW facility of membership, and this bill would hurt us. We're talking about families all the way from Central Virginia all the way to Bristol. We have membership, West Virginia, Tennessee, North Carolina that comes there. It's not every day in my line of work that we're on the same side of the company, but today it is very important. I'm not a politician, even though I'm the president of my local, but I come here because I value the importance of this. Thank you.
Thank you.
Yeah, Mr. Chairman, my name is Doris Krause-Mays, President of the Virginia AFL-CIO. Some will say that the plant is not going anywhere. And as a worker, there are sometimes fear and uncertainties. For those of you who do not know, I am from Southwest Virginia. I worked at AT&T manufacturing plant where over 2,000 employees worked, which is only 12 miles from the Volvo plant. We were number one in electronic components, and now it is closed and it went to Mexico. Now I have family and friends that work at Volvo. I'm not a lawyer in terms of the franchise and know anything about that. All I know is that workers work at that plant and they manufacture trucks in Virginia, and we need to make sure that we maintain the trucks made in Virginia. Thank you.
Thank you. 20 seconds.
Mr. Chairman, members of the committee, Fred Helm on behalf of the Alliance of Automobile Manufacturers, also speaking on behalf of General Motors. In the interest of time, I won't repeat the arguments we made before, but I did want to say to the committee, we appreciate the association and the VADA working on that amendment relating to the diversity programs. That is one amendment that was important, and we're glad to see that on the bill. On the crux of this bill, though, we still object. It is essentially overbroad and extinguishing a very important right of manufacturers to protect their brand. Thank you.
Thank you.
And I realize my time has expired, but I'm Morgan Philby, Corporate Counsel with Volkswagen Group of America, and coming to oppose the bill. We are based, our corporate headquarters for the U.S. is based in Herndon, Virginia. We have obviously a vested interest in the dealers in this state, and I agree with all the points made by my colleagues. I won't take any more of your time. Thank you.
Thank you. We're gonna have questions from the committee, but first, I want counsel, because a lot of us have been hearing about this court case, and I want counsel who I've asked to do some research to look at this case and just report a brief overview as to how it came about and what we're dealing with that's been brought up.
Mr. Chairman, my understanding is that there are two cases that triggered the introduction of this bill. The first case was resolved. The court ruled in favor of Volvo in terms of the breach of contract issue and under the statute, which is 4621569.1. The Fourth Circuit affirmed that. Then there was a second case. There was an opinion on that back in September of 2018. That case is pending in the Western District. It has, there's been a preliminary injunction that has been granted by the court in favor of Volvo to stop the sale, the 2018 sale. The defendants, which is Truck Enterprises, Inc., in this case, filed a motion to dismiss for mootness because, according to one of their pleadings, the agreement that is the subject of the second lawsuit no longer exists and has been terminated. The court has yet to enter an order to that effect, though.
So in your opinion, from what you have found, anything that we do, does it have any impact on this at this point?
Mr. Chairman, if there is no agreement at this point, then I hesitate to speculate what a court would do, but if there is no deal in place, then there is nothing to litigate.
All right, thank you.
Mr. Chair,
All
can
right.
I ask a question just on the court case before we leave that?
Sure, Senator McClellan.
Thank you. Counsel, on the first court case, you said that they ruled on the contract and the statute. Can you tell us what the specific question put to the court was on both the contract and the statute and how they ruled?
Mr. Chairman, Senator McClellan, the court ruled that Volvo had both a contractual and statutory right of first refusal. The contractual right of first refusal was impaired because the court held it was impaired as to Volvo because the agreement did not allow for them to exercise their right of first refusal because they did not parse out the value of Volvo, Kenworth, and Isuzu. It was the facts in the case are that there were, I think, 7 dealerships. 4 of them sold Volvo and Kenworth. 2 of them sold Kenworth and Isuzu, and 1 dealership sold only Kenworth. And so they bundled all of those dealerships together in one sale. And so Volvo was unable to look at the Volvo portions of the dealerships and decide whether or not they wanted to exercise their right of first refusal. Well, under the dealership agreement, that is a breach of contract. The statutory interpretation was about whether or not the Volvo had a right of first refusal under the statute that's being amended in this bill. It's the very first one in the bill. It's 46.2.1569.1. And the court concluded that, read any other way, the right of first refusal would be nullified. And so Volvo was entitled to exercise its right of first refusal with regard to just the Volvo portions of the dealerships.
Follow up, Mr. Chair.
Senator McClellan.
And so with the statutory right of first refusal, are there any restrictions on the exercising of that under current law?
Mr. Chairman, Senator McClellan, yes, those restrictions are all found in the bill in 2174, which, sorry, let me pull it in front of me. Currently, there are conditions to exercising the right of first refusal. The manufacturer has to notify the dealer in writing within 45 days of its receipt of the completed proposal. The manufacturer has to pay the reasonable expenses, including attorney's fees, and the exercise of the right of first refusal has to result in the dealer receiving the same or greater consideration that they would have received in the sale. This bill,
Senator Cosgrove.
Thank you, Mr. Chairman. Can I ask Mr. Hall from VADA a question?
Mr. Chairman, members of the committee, I'm Don Hall with the Virginia Automobile Dealer Association, representing all the heavy-duty truck dealers since 1943 in Virginia as well.
All right, thanks. Basically, we heard from Volvo Trucks and the folks who work with Volvo Trucks, but as we all know, VADA represents both auto and trucks. And so we're all a little confused about the court case and the impacts. We don't normally try to do legislation that's going to impact a court case, but can you give us, why are the Car Dealers Association involved in this?
Yeah, Mr. Chairman, Senator, I appreciate the question. The simple answer is this. The decision that the court made now turns everything, as we know, the right of first refusal upside down. It turns on its head, if you will, for lack of a better term. Meaning that a manufacturer can come in and cherry pick out the franchise they choose to cherry pick out. You're selling your 15 or you're buying 15 dealerships. They can cherry pick those out. Frankly, it drives down the entire value of the buy-sell. Someone thought they were buying it, someone thought they were selling it, and a manufacturer can pull that out. North Carolina does not prohibit this in their state, nor does the state of Maryland. Two states to the north and the south don't allow this. As a result of this court case, we knew we had a problem. We thought we addressed this 25 years ago. But the fact is we didn't have mega dealers like we do today. This dealership was willing to sell Volvo on its own. At the end of the day, it's a pretty simple argument, and that is their, meaning Volvo, is not willing to pay the price that the dealership is willing to sell Volvo by itself for. The law was very clear. We thought, and as a result of what happened in the courts, we felt compelled to come here. The failure to have this law in place opens up not only truck dealers in Virginia, but 500, almost 500 new car dealers as well. It's something that must be dealt with at this time. We cannot afford to wait 2 or 3 years. It's a property rights issue. It protects them, their investments, and those who buy those investments from them. And then finally, Mr. Chairman and Senator, the people buying today are not individuals. They're not small, a one-shop operator. These are mega dealers buying other mega dealers and other dealerships out. These are big, big players involving, could be $100 million plus dollars, $80 million. It's a lot of money. So this is it's big stakes when it goes on. It's not something that's small and just an easy buy sell these days.
Thank you, Mr. Chairman.
All right, Senator Newman.
Maybe someone from Volvo or something like that. I'm struggling with two aspects of this. First, if someone has a dealership that has got Jaguar, Volvo, mostly for cars, right, and they've got a big lineup, how is it determined what the value of the the one dealership is that you have a first right of refusal for when you're really looking at a strategic sale, not an asset sale? In other words, how do you get the right value for the one portion of that dealership as opposed to what's left over?
Well, let me first say I can't speak to cars. We're talking about heavy trucks when we're talking about Volvo trucks, and those are 18-wheelers, as most people would refer to them.
All right, let's say Freightliner International and Volvo.
Sure. The Volvo is required to step into the shoes of the purchaser, right? So Volvo doesn't ever set the price in a buy-sell transaction between one dealer and another dealer. So whoever the buyer is, they just have to designate what the price and the terms and conditions are for the Volvo portion. That was the basis of the lawsuit. I respectfully disagree with the VADA that they provided that value. It didn't happen. We're entitled to step into the shoes on the same terms. That's what a right of first refusal says. So whatever terms have been agreed upon, I believe the attorney for the committee pointed out that the statute specifically enumerates how the value is calculated.
Mr. Chairman.
Senator Newman.
But I'd like to hear someone else help me understand. In a real case where you have three different dealerships, one is not a very good dealership, the other one, but sold together, there's a strategic value, and you're building maybe separate portions, but handles that case. How do you accurately come to the same price by selling all three separately, or one, then two and two, to get to the strategic value?
Sure. We have a case ongoing right now when in another state, it's in Louisiana, where a package deal was presented to us, and we said, you cannot commingle the Volvo portion with the competitive brand. You need to split out the Volvo portion. So they rescinded the stock purchase agreement, and then they entered into an agreement for the competitive brand, and then they separately entered into an agreement for the Volvo portion and presented us with that separate agreement. We were left to live with whatever values were apportioned for the assets that were in either one of those two deals.
Just one last question.
Senator Newman.
So did the entire price add up to the strategic value cost that was being offered by another dealer?
I believe it did, but I don't have those numbers in front of me, but I believe it did.
All right.
Mr. Chairman, thank you. I do have questions about the lawsuit, but I'll wait for a little bit.
All right, any further questions?
Yes, Mr. Chair.
Senator McClellan.
Thank you. I have two, maybe three. So I thought I heard one of the witnesses compare the number of auto dealers to the number of truck dealers. Can you repeat that number again?
Yes, I believe, based on a conversation I had with the VADA earlier this week, or perhaps last week, they informed me that it was approximately 500 new car dealerships in the Commonwealth, and I believe they said 12 to 15. I think we thought it was more like 17 for trucks.
So let me ask it this way.
Senator McClellan.
Sorry, thank you, Mr. Chair. So let me ask it this way, and this may be a VADA question. How many current franchise agreements are out there for auto dealers roughly compared to truck dealers? And let me tell you why I'm asking. So when we passed this bill, the first part of it says, notwithstanding the terms of any franchise agreement. So if the court has ruled that someone has a right of first refusal based on current law in their franchise, what I'm trying to figure out is, by statutory fiat, how many franchise agreements which were entered into based on current law are we going to change, and thereby change the terms of how that franchise agreement was negotiated?
Mr. Chairman, Ann Gambardella with the Virginia Auto Dealers Association. There are, I don't know the exact number of individual manufacturers, and they have form agreements. So it wouldn't be the number of dealers, it would be the number of manufacturers we have. But I would like to point out that every franchise agreement that is submitted to a Virginia dealer is required to have a statement in it that says that this agreement, insofar as it contravenes the laws of any locality, any state where it's to be executed, is amended as necessary to comply with the law. These contracts are amended all the time. The manufacturers amend them all the time. So it is fully recognized in the industry that by law, these amendments are going to happen, and that the contracts are amended by those
So
actions.
if the law changes, then they amend.
Yes, Mr. Chairman, that's correct.
All right. Senator McClellan.
Final question, Mr. Chairman. And I don't know who can answer this, but would you say there, and I really don't know the answer. Would you say there is a difference in the bargaining power between a manufacturer and a franchisee for 18-wheeler trucks versus automobiles? Or would you say that the bargaining power between the two is the same?
Mr. Chairman, Senator McClellan, I would say that in each case you have a business owner. In our parlance, they're often the biggest small business in town, but they are small business owners, and you have international corporations. So yes, there is a disparity of bargaining power across the industry, whether it be cars, trucks, and we don't see a difference. That's why this entire body of franchise laws in Virginia and in every other state applies to these agreements, because there is such a disparity of bargaining power. The franchise laws in Virginia have applied to car and truck dealers since their inception, and the reason is that they're very similar in the pressure they get from their manufacturers.
Can we hear the answer from the manufacturers as well, please?
All right. Real quick.
Yes, thank you. I would say if this bill passes, it removes any bargaining power on our part. We heard from some dealers today who were third or fourth generation dealers. They are already protected to pass it down to their family members as the current statute provides. We also heard from people who were employee owned, and managers are protected in the current statute. But if this bill passes, then it will eliminate any right for us to choose who we go into business with, and instead Volvo will be left to accept Kenworth dealers or international dealers from Utah or Nevada or California. And it's not fair to force us to take someone else's dealers.
Senator Newman.
Mr. Chairman, maybe Fred or someone like that. I want to understand the current lawsuit just a little more. And the question, I guess, is, so how quickly will there be resolution? Right now, it seems like the court has said that or the deal might be withdrawn. So how quickly will this self-settle if the legislature doesn't involve itself, or say we were to consider a delayed enactment? How quickly is this going to get settled?
Mr. Chairman, the original response to the motion to dismiss was supposed to be due tomorrow. Volvo has extended that response time to to February 25th. The issue is that no matter what happens in that dispute, and again, the parties have withdrawn the contract, so we don't see that there's a dispute left for the court to look at. No matter what happens, the original case is still in place. That will not get resolved in the current under the current agreement. The court has already ruled a manufacturer can peel off this franchise, so this is why we need this assistance in this bill for all of our car and truck dealers.
All right.
So, do manufacturers agree with that? When is resolution coming?
Well, Your Honor, sorry, I'm used to arguing in court. Okay. Sorry, Senator. We vigorously oppose the motion to dismiss, and so we will be filing our brief in opposition of the motion to dismiss. I don't think it's appropriate for us to comment on our legal strategy as to the arguments that will be in that brief beyond what I commented on in my initial comments. But I can't predict how long the federal court will keep the case once we respond. I mean, it's up to Judge Dillon at this point.
Cosgrove.
Thank you, Mr. Chairman. Just a quick question. It was mentioned that the decision was delayed until February 25th. Who requested the delay, and when was that done?
We requested a motion for extension of time. It's routine in litigation.
When was that, Mr. Chairman? When was that done?
I don't know. A week ago. I'm not sure when it was filed, but they filed the motion to dismiss the day after this passed the day after this bill passed through the House and passed through the Senate. And then we filed a motion for extension of time, which is a common practice, to say the least.
So did you ask for the 25th, or is that what the court said it?
I'm not sure what we asked for, but that's what the court ordered. So the
Right.
way that an extension of time works is you request time from the court, and then the court issues an order, and that's the day that you have to respond.
All right, Senator Favola, and then we're going to wrap up the questioning so we can vote.
Thank you, Mr. Chairman. My question will be, I think, simple to answer, but I'm going to address it to council. Have we ever had a precedent where we have applied an enactment clause to a bill that had language pending the determination of a specific court case, as opposed to language which gave a date specific?
Mr. Chairman, Senator Favola, not that I'm aware of. There are enactment clauses that put other conditions on the effective date of a bill, but none that I'm aware of tied specifically to a court case or any type of pending litigation.
Mr. Chairman, a quick follow-up question.
Senator Favola.
In theory, and maybe in practice as well, it would be possible to select a later date and date certain and put a condition on related to the completion of a court case or a specific finding or.
Mr. Chairman, Senator Favola, I don't think that you can do both. I think you need a date certain or a condition, because if the condition doesn't take place before the date certain, then it will become effective upon the date certain.
Depending on whether I do and or. Just
All right.
kidding. Just kidding. I could do or. Okay.
All
thank you.
right, I want to let the delegate wrap up, and then
Thank you,
you have a
Mr.
motion.
Chairman. As it's been noted, this sale has been canceled. So at the end of the day, Volvo has no right of first refusal to a contract that no longer exists. It's unfortunately that it has been filed a motion dismissed to conveniently be set for 2 days after we leave town. I'll let the committee determine what were the motives of that. One of the things that frustrates me in hearing this testimony is there's quotes here today. It says, Volvo wants to be able to choose our own business partners. I don't disagree with that. But there is a bundle of rights already under 46.2-1569 Section 3 that are broadly written, broadly constructed, that give Volvo those rights. That includes they can deny a sale for lack of good moral character, lack of reasonable motor vehicle dealership management experience, lack of financial ability, fails to meet standards otherwise established by this title. Include, furthermore, in 1569, they can block the sale or transfer of a franchise without the franchisor's consent if they try to relocate the business. So there are a large number of rights already under 1569 in the code that gives Volvo exactly what they claim this bill will take away, which is their right to do business with who they want to do business with. That's completely separate from here. That's already in the code. I don't care what state you're in, right of first refusal is always traditionally meant to be you step in the shoes of the prospective buyer. You don't treat it like a cafeteria where you pick and choose. So I think this is a much-needed bill. I think this committee has already heard similar legislations passed through, and it's the pleasure of this body to pass the bill to the floor.
All right, do we have a motion on the bill? It's been moved. Is there a second?
Mr. Chairman, I will second it, and then I'd like to speak to the motion.
All right.
Mr. Chairman, I have a amendment at the desk. I'm not going to use it right now, but it basically had a delayed enactment date until January 1st when some of these things could be kind of worked out. Honestly, I think some of us coming here just as truth seekers. I don't care about the politics. I don't care about the people. Really, it just what's right. Is there an ongoing lawsuit? Is it not? And then beyond that, honestly, I think the policy, because no one can answer the strategic purchase question, probably the law needs to be changed, right? So that's kind of where I am. I'm not going to offer the amendment today. I would tell you that between now and the floor, Council's done a pretty good job, but I'd really like to better understand the statement of this has been canceled. If it is, and that's a different year, but where are we legally? So, Mr. Chairman, I'm not going to offer my floor amendment or amendment today. We'll think about it between now and the floor and kind of if it makes it that far, sir.
All right, we have a motion and a second to report All in favor, vote aye on electronic voting board.
11 ayes, 2 nays.
Bill reports 11-2. Delegate Hugo.
Close to what you wanted.
All right, Delegate Hugo, we have your bill, which is House Bill 2514. It is identical to Senate Bill 1335, Senator Barker's, that was PBI'd in this committee.
Yes, sir.
One of the issues that I brought up that we were trying to address is some things that came up during the beginning of the session with Senator Cosgrove and I about being able to have enough, because the state police administers this program, having enough people that can certify these inspectors and get them out into the field.
Yes, sir.
And we felt his bill did not reach that goal. So if you'd like to just speak to your bill, and then I may have an amendment.
Mr. Chairman, thank you. And I think the committee's familiar with the bill. The safety inspectors, the men and women using their hands to not just make the cars safer, to make it safer for all of us and our families. They haven't had a raise in 13 years. This bill would take it from $16 to $20, be a $4 increase that would go straight to, again, the men and women who are doing the safety inspections. And I know you had some suggestions, and I'm always open since I saw what the alternative was on the other.
Well, I think we're asking a lot of the department that administers the testing and all for the operations of this program. That my suggestion would to appropriate 20 cents from this $20, which would give state police, which is now receiving 70 cents in order to administrate this program that you're asking to increase the cost on.
Yeah, Mr. Chairman, and I would say, I know I believe you had a discussion with someone finance and
Yes,
House Appropriations.
I spoke to Chairman Jones. Chairman Jones is well aware of what the dilemma is. I've had a conversation, Senator Cosgrove and I, earlier this year with the Auto Dealers Association, who is in full support of the inspection program, but their dilemma is trying to get these individuals trained, tested, and out there for the ability to inspect these vehicles, and without some kind of increase in their administrative process, we're still going to have that problem.
I understand where you're going, Mr. Chairman, and I was trying to do something different too, which I appreciate what you're after. We were looking at in some rural areas and even some urban areas that were having a problem just finding safety inspectors themselves because of making the pay. But I think maybe working together, we can solve both problems.
So could I offer a line amendment to address the 20 cents?
Mr. Chairman, that amendment would be on line 27, strike 50 cents, insert 70 cents.
All right. It's been moved and seconded that we
Mr. Chairman,
accept.
just a question on that.
Yep.
What would that 20 cents, what would that raise statewide?
1.6 million.
1.6, thank you.
Yes.
Does that now turn this into a revenue bill?
It does not.
Sure.
Yep. Check that out before we got here.
That's why I asked you to go talk to the Finance and Appropriations. I had that similar concern, Mr. Chairman. Thank you.
All right. All right. There's a motion and a second. Is there, all in favor say aye? Aye. All opposed? All right. Now we have the bill before us. Is there a motion on the bill? Is there a second? Is there a second? Is there a second? All right, all in favor, vote aye on electronic. All right. Did you want to ask? All right. Sorry, close the roll, strike the roll. Senator Cosgrove.
Thank you, Mr. Chairman. We had this discussion with Senator Barker on his bill here, and this is a 25% increase. I understand there hasn't been an increase in inspection fees in quite some time, but the whole idea with inspections, basically, it's customer service, it's getting to know your customers, bringing your customers in, and doing repairs on vehicles that don't pass inspection. So this is a huge increase, and I understand the desire to have that extra 20 cents to 1.6 million for state police. But I just feel this is way too much of an increase, and I hope that we won't support this bill. We didn't support Senator Barker's, and with all due respect, it's nothing personal, but I don't think we should support this bill either. All right, I'm done.
All right,
Mr. Chairman, just
Senator or Delegate Hugo.
Just 30 seconds. I'll be blessed to be the brief. I mean, we have 8 million cars on the road, and about 17% fail a year. So, I mean, we've got about 1.3 million cars that have a problem. And what we're trying to do, again, is make sure we're protecting not the cars, we're protecting the families, the people in the cars on this. I think that's where we're going on this. I hear what you're saying, but it's been 13 years. And that was the point we were trying to make on this. So we thought this was a reasonable number. If the committee thinks different, I can understand that.
And I'll add that 13 years ago, the motoring public wasn't traveling as many miles as they do today. And the number of highway miles opposed to 13 years ago has dramatically increased. And so you have wear and tear on the tires, on every brakes, all that. 30,000 miles, you're going to have to really replace all that. So I think that's one of the issues for the 13-year.
And lastly, Mr. Chairman, my understanding is from some of our members that are familiar with this more than I, they're having a problem just because of the the $16 in the payroll. They're having a problem just finding people to do it and making the payroll. It takes about 30 minutes to do an inspection. In fact, you have to log in on the computer, so you really can't do many more than that. And even with the nominal increase, that's less than the $20 when a mechanic labor rate ranges from 60 to 140 an hour. So we're just trying to, we're not trying to be, I hear you, I appreciate your concern. I'm not trying to be overly aggressive on this. It was just a number that I thought we had worked out. But I appreciate Senator Cosgrove's comments as always.
Senator Newman.
Tim, I'm a bit where Senator Cosgrove is.
Yes, sir.
I'm not. I don't strongly feel in opposition to it. Matter of fact, I think it probably needs to go up. We'll see how the vote goes, but
Yes,
if we don't quite make it, there's probably another number that can get us there. We'll see, but you
Yes,
may
sir.
get there.
Well, I appreciate y'all hearing me out today. Thank you very much.
All in favor, vote aye. All opposed, vote no.
Seven ayes, 6 nays.
Bill report 7-6.
Just get in my teeth. Okay. Thank you. Yeah, I'll leave.
Run
Say
while
thank
you
you and
can.
leave quickly.
I'm gonna go ahead and take up Delegate Peace's bill. It's a special license plate. Oh, do
Want to
you?
do the second one or?
Okay, I'm sorry, I didn't see it.
Yeah.
House Bill 2527.
Yes, sir.
Dealing with District 8 and tolling
Yeah,
on.
and with the.
Which road do you not want tolled? Which road do you have left that you don't want tolled?
It's obviously the chairman has read the amendments that scales it back just a little bit. And right now, obviously, it's a fingerprint that could apply to anything, but right now it applies to the Fairfax County Parkway and the Prince William Parkway in Fairfax and Prince William, Virginia. Tolls are a tool that we should use, but this was Fairfax County just did a study, and there were of nearly 2,500 comments. There was strong opposition to tolling on this, so I appreciate you. Thank you,
All right.
Mr. Chairman.
Any questions of the patron? Is there a motion?
Mr. Chairman, I just a question, and again,
Senator Cosgrove.
I'm sorry, Tim, but, in Chesapeake, we've tolled our roads in order to build them. We've also taken the HOV lanes in our planning district, and we started tolling those, and that's not for adding lanes there. So I guess what I'm looking at is, if we start taking away the ability of localities to do this, I'm a little concerned. We're doing it in one area, but we're going to not do it in another. But you already have toll roads down there with Dulles Greenway and other
Yeah, Mr. Chairman,
toll roads.
we have Dulles Greenway, we have the 395, 95, we have 66. This just says that if CTB were to do this, they've got to come back to the General Assembly, and they couldn't do it on their own. I do believe tolls are a tool. I agree with you, and I've supported tolls in the right case. But on these two roadways, and I know it goes through Delegate Senator Marsden's district also, because of the suburban neighborhood nature of these roads, it would just be highly problematic. And we're just saying you've got to come back to the General Assembly.
Mr. Chairman.
Senator Marsden.
Thank you. It's getting to the point, a lot of these roads are just more for local usage than they are long-term transit, which is what tolls have traditionally paid for projects that go over barriers like rivers and they're interstates that, cover long distances and what have you. And, pretty soon you're going to need a toll to get out of your driveway. And I think this is a good speed bump to have to get this back before us, because it's just become too convenient to just say, well, let's just toll it. Thank you.
And like I said, it just doesn't say no, it just says come back to the General Assembly. But I appreciate the Senator's comments as always. Thank you.
All right. Anyone else have any questions? If not, is there a motion?
Second.
Moving second, report the bill. All in favor, vote aye on electronic voting board.
Thank you, sir. A little more love.
10 ayes, 0 nays.
Thank you. Thank you all very much for your time today.
Thank you. Next, I'm going to Delegate Peace's bill, which is a special move over license plate, which he has all the It's been moved. Is there a second? Second. And all those in favor vote aye.
Ten ayes, 0 nays.
Bill reports 10-0. Next, I'm going to take up Delegate Bagsby's bill. His bill simply is asking the Department of Rail, Public Transportation, and all the stakeholders to evaluate the placements of maintenance and highway signs along the Amtrak and report back to both Chairman of Transportation in the House and Senate by December 1, 2019 on the findings of that.
Move to report.
It's been moved and seconded that we report the bill. All in favor vote aye on electronic voting board.
10 ayes, 0 nays.
All right. Delegate Jones. Welcome.
Thank you, Mr. Chairman. Members of the committee, I believe I have House Bill 2489 in front of you this afternoon.
Evacuations, well, you don't want to collect tolls, people trying to get out from the water?
Not when the governor
Can't imagine that.
is telling you to get out and you got to leave. This bill came about from Hurricane Florence, the near miss back in the fall. We had a lot of folks who were forced to leave for the first time in their entire lives, and we got a lot of phone calls in my office about folks who were a little bit disappointed because they might not have an easy pass. They might not normally use those roads because that's the only way to get out. So we worked with some stakeholders to try to get to a point where we could have this legislation and require the commissioner to suspend toll collection in the event of mandatory evacs. And I think this is sort of the byproduct of all of that.
Senator Cosgrove.
Thank you. A question for Delegate Jones.
Yes, sir.
I'm supportive of your bill.
Thank you.
But there is a contractual obligation between the Commonwealth and ERC. There's also a contractual argument with the South Norfolk Jordan Bridge. We don't actually have a contract with them, but it's a privately run operation.
That's right.
Two questions. Number one, do we have a contractual impact with ERC that we're going to have to pay for as a Commonwealth? Mm-hmm. And secondly, does this affect South Norfolk Jordan Bridge?
So to your first question, Senator Cosgrove and Chairman Carrico, this doesn't affect ERC at the moment because that's actually not an evacuation route as determined by VDOT.
Really?
Am I correct on that? The answer is yes.
Okay.
That's not to say that it might not be in the future.
Let's just bring VDOT up while we're here. Joanne, you want to?
Mr. Chair, and I can further expound on that, the answer to that question. The language in the bill that would, if ERC was ever on an evacuation route, also indicates that the evacuation order has to comply with the provisions of the comprehensive agreement. So So bottom line, and much of the language is very similar to the comprehensive agreement. A lot of these comprehensive agreements do have mandatory evacuation provisions, so.
Mr. Chairman, if I can ask Joanne.
Senator Cosgrove.
The South Norfolk Jordan Bridge, private enterprise, is that evacuation route?
Mr. Chair, I'm not sure that it's a private or it's an evacuation route, but we don't believe that it's impacted by this bill.
Okay, all right, thank you.
All right. Any other questions?
I move to report.
It's been moved and seconded to report the bill. All in favor, vote aye on electronic voting board.
10 ayes, 0 nays.
Bill's reported.
Thank you, Mr. Chairman. Appreciate your time.
Delegate Carr.
Thank you, Mr. Chairman. Members
Thank
of
you
the
for
committee.
coming.
Currently, a person who fails the DMV written test 3 times must take a refresher course before being eligible to take the DMV test another time. However, it is only presented in a classroom setting by DMV authorized driver training schools. DMV reports that approximately 40,000 people have failed the test 3 times, around 10,000 per year. HB 2717 would provide an alternative online video of a classroom presentation with charts and illustrations shown simultaneously as sidebars. The course would be timed on an online learning platform with security arrangements to assure that the person taking the test is the person who took the test. Students taking the course would be monitored by a qualified instructor who would certify successful completion. Upon notification to DMV, the students would be eligible to take the DMV test a 4th and subsequent times. Online courses are more accessible to more people and is available at any time. The bill, if passed, would clarify the DMV's authority to approve an online course. Mr. Randy Rollins, Executive Director of Drive to Work and former Secretary of Public Safety, is available here today to answer any technical questions.
Thank you. Is any technical questions from the committee? Senator Cosgrove.
So we're going to have an online course for this. Is the test taken online?
Senator, there's no test required. The standard is substantially satisfactory completion under the current law.
So the test is done at DMV when you go back to retest
The test would have
after
to
you
go back
fail.
to DMV and take the test again.
So it'll be properly proctored then?
Yes.
Okay, so like I couldn't get Senator Carrico to take my test for me?
I wouldn't.
I'm afraid what it looked like.
Yeah, I was going to say you wouldn't want it.
That's all I want to know. Thank you.
We've worked with DMV too to get the language right on this too, so.
Yeah, they said they're okay. All right, any other questions? All right, so motion to report, is there a second? All in favor, vote aye on electronic voting board.
Eleven ayes, 0 nays.
11-0.
Thank you,
Bill's
Mr. Chairman.
reported. Do we have Senator or Delegate Pillion? David, you going to present his bill?
Mr. Chairman, if that's all right, Delegate Pillion's authorized me to do so.
Right, it's, let's ride a scooter on Highway Day.
Mr. Chairman, members of the committee, David Skiles with the Vector Corporation representing Uber and its subsidiary Jump. Delegate Pillion's House Bill 2752 is a pretty simple bill. As you know, the Commonwealth has been a leader in transportation innovation, and as part of that, we are seeing both throughout the Commonwealth and throughout the country micro-mobility platforms, i.e. e-scooters and e-bicycles, or electric scooters and electric bicycles, which are popping up in localities. House Bill 2752 would really do 2 things. One, it would update the Code of Virginia to recognize these new types of devices. The definitions in the code are out of date. And then secondly, it would affirm a local government's ability to regulate these types of devices. Right now, there are a number of pilots going on throughout the Commonwealth, especially in Northern Virginia and some in Hampton Roads. And so the legislation would not interfere with those pilots. We've worked the language out with local governments, and I believe there are representatives from both VML and VACO, as well as some individual localities that are in support of the legislation. But that's what the bill does in a nutshell, and I'm happy to answer any questions.
So it's my understanding localities can prohibit these or allow them.
That's correct, Mr. Chairman. The language in the bill does authorize the locality to regulate these devices. If after a certain period, which would be January 1, 2020, a locality has not taken action, the devices would be allowed. So the default would be that they could be allowed. But that does not prohibit a locality from coming back at a future time and passing an ordinance or an administrative regulation.
Okay. Senator Cosgrove.
Is this the Hillsville scooter bill or what? I mean, it's kind of like, I don't like the scooter the way it's been done in the past. All right, it's just we take the scooters in, dump them in town, and we'll ask forgiveness later.
Well,
does this deal with any of that?
Mr. Chairman and Senator Cosgrove, that's an excellent point. And certainly, as you have seen, localities are dealing with that through either administrative regulation. One of the examples, obviously, Norfolk, who I believe there's a representative here, is looking to pass an ordinance. City of Richmond is doing the same. And so the idea of this legislation is really to affirm a local government's ability to regulate. And we think in working with local governments that this will certainly incentivize, and as these devices continue to become more and more popular, local governments are looking to pass those regulations.
Mr. Chairman, can I hear from Norfolk?
Sure.
Just very briefly.
Hi, good afternoon, Mr. Chairman. Morgan Whalen from the City of Norfolk. And I said we worked with the patron. We wanted to be very clear that Norfolk could continue to confiscate the scooters. We have about 600 in place right now until we rolled out our pilot program. We think this bill allows us to still monitor our streets and do our RFP and pilot and does not take away our ability to do either one.
All right, thank you, Mr. Chairman.
Thank you.
Mr. Chairman.
Senator Marsden.
Editorial comment.
Well, we always
similar.
love those.
I know you do. But just recently we passed a thing on short-term rentals and gave localities the right to regulate these things. And the next thing you know, as soon as everybody didn't like the regulations that the process developed in the locality, boom, here we are back in the legislature for the state to decide what's right for localities. And I hope we don't do this here. If we give this authority to the local jurisdictions, unless there's something constitutional going on, let's keep it with the localities and resist the urge to legislate this stuff from Richmond. Thank you.
With that, with that editorial, do you have a motion?
Move to report.
It's been moved and seconded. We report the bill. All in favor, vote aye on electronic voting board. Can you give us a brief on William S. Stanley? What was the gentleman you were talking about last night that only you and Don Hall knew of?
11 ayes, 0 nays.
Bills reported 11-0. Last bill is Delegate LaRocque's. This is dealing with parking access islands adjacent to parking spaces. If you recall, when you see a handicap parking space, there is a space that's marked with lines where you allow a wheelchair access to come out and have room to get out of the van. This is addressing a penalty which I thought already existed, that they can't park in that zone. I thought the indicators on the painting indicated a no parking area, which already had a penalty. But I may be wrong. But I have a question to council.
Mr. Chairman, I think that is not as simple an answer. There is a section that allows the Commissioner of Highways to designate areas by painting. They're called traffic control devices. But there's nothing that specifically says you can't park in these access aisles, although I think that in the past they maybe has been treated as part of the handicapped space. Again, there's nothing specifically addressing the access aisles.
So probably then there is prohibited on highways, but not in private parking lots.
Mr. Chairman, the definition, it's a little ambiguous. The definition of highway does include every way that is open for the public to travel.
Right, parking lots is that. Okay. Delegate LaRocque.
Committee waiting.
Yours is the last bill. We're just talking about whether that's already a law that you can't park in those areas or not. I thought that once you stripe that off, it's designated for no one to park there and already a violation of the law, but maybe you can enlighten us that it is not.
Probably no more so than council. I know that the gentleman that brought this to our attention inquired to local law enforcement, was told that it was not a violation, so that these vehicles that you see in the pictures could not be ticketed.
Anybody can be ticketed. You just convict them. That's the problem.
You would know better than I, Mr. Chairman.
Yeah.
Mr. Chairman, I am aware that there are local ordinances that prohibit this specifically. Whether or not they were authorized to do that under the Dillon rule may be another question.
Okay. So local ordinances could do this, but the bill would be needed in order for them to do it? Okay. All right.
I think the pictures, the bill, it pretty much speaks for itself, Mr. Chairman. These are needed for the offloading of wheelchairs. Very often, I think they're gives access to the sloped area where a wheelchair would cross the sidewalk, and I don't think I can add much to it. Thank you.
All right. Anyone on the committee have questions?
Chairman, are you ready for a motion?
I'm ready.
I move to report the bill.
It's been moved second and we report the bill. All in favor, vote aye on electronic voting board.
11 ayes, 0 nays.
Bill reports 11-0.
Thank you, Mr. Chairman, members of the committee.
All right, that completes our calendar. Thank everybody. Hope you can make the dinner on the 19th. And we're adjourned. Thanks.